I'm Leslie Moore from Chico, California. The law enforcement family committed numerous crimes against me and my family in retaliation for my making a complaint against a police officer. Those crimes include child abuse. The child is Kenny. He was born into my family as my non-related grandson. He lived with me much of his life because his mother wanted me to adopt him, and I was in the process of doing so. When Kenny was about 4.5 years old, I was battered by my husband, a Chico police officer. When I called the police for help, Officers Merrifield and McPhail responded by telling me that my domestic problems are none of their business. So I got a restraining order from the court. Then the police decided that my domestic problems were their business, and they began to harass me to give a statement to an investigation. I wasn't interested because my husband was already out of the house, but when I learned that my husband had lied about the abuse and that the officers I had reported to had lied about my report, I agreed to participate in the investigation. The investigator was Rick West. He refused my evidence, and then he used threats and finally fraud to discourage me from participating in the investigation. But there was a witness, Kenny, so they detained him. Linda Dye, Scott Franson, and Gary Castillo of the Chico Police Department provided armed guard, while Aaron Sweet, Jorge Lozano, and Patricia Parra of CPS took him from his daycare. Kenny was in no danger, and they knew it. Under California law, detaining any child that is not in imminent danger of serious injury is kidnapping. Then David Kennedy, the attorney for CPS, filed a petition asking the court for an order that Kenny never be allowed to come home. The judge can't make such an order if the offending party has left the residence. So the kidnappers falsely claimed that the domestic violence Kenny had witnessed had occurred just prior to the detention instead of nearly 4 months earlier as they knew it had, and they didn't mention the fact that I had gotten the restraining order. So they also added a false claim that I had allowed Kenny's mother unauthorized visits with him at our home. According to both state and federal law, I must be given due process in the hearing on the petition. In a due process hearing, I could have easily shown that both of the allegations were false, but the judge, Tamara Mossbarger, ordered the use of physical force to restrain me from even entering the courtroom for the hearing. I was allowed in only after the hearing and only to hear the decision. Kenny would be adopted out to strangers. So based on false allegations and with no pretense of due process, Kenny lost his home, his entire family of origin, all of his pets, and his many teachers and friends, all in one fell swoop and forever, without a single goodbye and without a single toy or a book or a piece of clothing of his own to take with him. There are no adequate words to describe what the trauma of the abduction and the torture of being rendered completely helpless to protect Kenny from this abuse did to me and my family. Federal Justice Weinstein explains it this way: in order to detain any child, even a foster child, because they witnessed domestic violence is illegal and unconstitutional, resulting in punishing the child and the non-offending caretaker and desecrating the fundamental precepts of justice. Yet Judge Mossbarger imposed that punishment on me and Kenny, and the only thing that was actually proven in her court is that the police, prosecutors, social workers, attorneys, and judges can commit heinous crimes and get away with it. The list of crimes committed in this conspiracy includes police officers making false statements to an investigation, preventing me from providing the evidence for an investigation, using fraud and threats to dissuade me from participating, kidnapping, perjury, false dating, exclusion of exculpatory evidence, obstructing justice, perverting the intent of the law, child abuse, and depriving us under color of law of our civil rights. I've presented proof of these crimes to the police, the sheriff, the city council, the board of supervisors, the grand jury, the district attorney, the attorney general, the governor, the FBI, and several state and federal justices. Despite the evidence, not one of the criminals has been charged. The number of people covering up for these child abusers makes the Sandusky cover-up look small. Congress has the authority and the duty to impeach any judge that deprives a citizen of constitutionally protected rights without due process. A formal resolution to impeach Judge Tamara Mossbarger is in order. Failing this duty would be a declaration by Congress that we are, with your knowledge and support, a lawless America, because the laws enacted by Congress are not worth the paper they are printed on when judges freely violate them and Congress allows it. The Constitution that Congress swore to uphold requires you to impeach Judge Tamara Mossbarger and each and every judge that knew of her act and did nothing about it. A couple months later, I got notice that Aaron Sweet had listed my name on the Child Abuse Central Index for emotional abuse, witness to domestic violence. She never interviewed me for her investigation, which is a crime, and then she committed the crime of falsely representing to the state that she had interviewed me for her investigation. I have a right to a hearing to grieve the listing. When I requested the hearing, it was revealed that Aaron had only listed my name on the Child Abuse Central Index, but not the name of the perpetrator of the domestic violence. They couldn't have a police officer listed on the Child Abuse Central Index, so they simply decided, without having the hearing, that I had made a false report of domestic violence, and they took my name off the list. They, of course, didn't inform Judge Mossbarger that there was no need to continue Kenny's detention, since they had now decided that there had been no domestic violence for Kenny to witness. There still hadn't been any proper investigation or due process hearing, so since making a false allegation against a police officer is a crime, I demanded that they arrest me because it would be much harder for them to deprive me of due process in criminal court than it had been to deprive me of due process in the secrecy of the juvenile dependency court. They, of course, refused to arrest me, knowing that the real crimes and criminals would be exposed if I'm ever afforded my right to due process in any venue. Then the divorce trial proceeded. My husband did not disclose major assets, and he blocked me from discovery, so I filed a motion to compel disclosure. Judge McNellis was assigned to decide the motion, even though he could not legally make any decision in the case because he had previously recused himself. He, of course, denied my motion. The delays were causing me to lose $2,786 per month in monthly retirement income, and though my husband was making over $11,000 per month in wages and benefits, and my income was $1,857, I was made to pay my own legal costs, which were astronomical due to the non-disclosure. Eventually, all 15 Butte County judges recused themselves due to their relationship with my husband, and it was decided that a visiting judge would be assigned. Instead of following the law requiring the court to request the administrative office of the courts to assign the visiting judge, a different recused judge simply gifted the case to Butte County's own 13-year full-time visiting Judge Lamb. So trial was set without disclosure and with an improperly assigned judge, and I could no longer afford an attorney. When I informed Judge Lamb that I still didn't have disclosure, instead of following the law mandating Judge Lamb to sanction the non-disclosing party, he threatened to sanction me for not wanting to watch a trial that I couldn't participate in without disclosure. At trial, Judge Lamb reversed the order of proof because the respondent had an attorney, and though the judge is not to decide any issue until both parties testify, Judge Lamb had adopted respondent's numbers and decided all but 3 issues before my testimony. In violation of the evidence code, I was not allowed to testify regarding the retirement benefits, and my testimony regarding the three remaining issues was blocked because I didn't know how to act like an attorney. I wasn't allowed to argue because I hadn't been allowed to testify. The community property was worth about $520,000, and there was no debt. So I should be worth half of $520,000 or $260,000, but I was awarded just $97,000, and I had to take a loan to pay my husband to equalize his keeping the undisclosed assets out of the equation. It will cost me $136,000 just in interest to pay off the loan, so instead of being worth $260,000, I'm actually worth negative $39,000 for a total actual deprivation of my property without due process of $299,000.